Hi everybody, this is Property with Leonard and welcome to another episode. Now on this channel we discuss property, finance and investments. Now please note that none of my videos constitutes as financial advice, but if you are looking for financial advice, please speak to an accredited and registered financial advisor. Now divorce is an emotional and difficult time for all parties concerned. The consequences of dealing with immovable property in particular can be further reaching than the parties initially anticipated. It is best, and that is my advice to you, to cater in detail for the disposal and the splitting of the parties' assets by agreement at the time of divorce. However, in my experience in the capacity as a commercial mediator and master real estate practitioner, this is much easier said than done. Unnecessary disputes and delays are often the order of the day. Even if there is a court order or agreement in place, some find it more difficult than others to deal with the realities of the divorce, whether it is because they still love the other party, the other person, and hope that things will somehow still work out, or out of spitefulness, they implement some delay tactics. This is a highly volatile and emotional environment that needs to be approached in a calm and collective way. Now, marriages in South Africa is a voluntary institution. There is nothing that compels any one of us to enter into legal contracts when we decide to commit to one another. But at least when it comes to owning fixed property, it's not the romance that should concern you. Not at all when you set out. It's what might happen when the partnership ends. In this video, I'm going to cover the following, and I will leave some timestamps for you in the description below to make it a bit easier for you to navigate through this episode. The first scenario that I will explain to you in detail is what should happen if the property is registered in both parties' names or only the husband's name, but in terms of the divorce order, the wife is entitled to the property or vice versa. And the second scenario, if in terms of the divorce order, the property is to be sold and the parties will split the proceeds. How does that work? And thirdly, what if the divorce order is lost? In scenario 4, you and your husband were married out of community of property, and the property was purchased by the spouse before or during the marriage. In the fifth scenario, you were married in community of property, and the property was acquired before the marriage, and the property is noted to only be registered in the name of the spouse who purchased it. And now that spouse wants to sell the property. And in the last scenario that I will explain to you in detail is what will happen if the husband was married in community of property but is subsequently divorced and he remarried in community of property to his new wife. Make sure that you watch the full video and give it a thumbs up and leave me a comment in the comment section below as well. Those things are really helpful. If you subscribe, like and comment, it's good for the YouTube algorithms, and that way we would grow and YouTube would recommend this video to more people like you who YouTube knows would be able to benefit from its content. The law of South Africa recognizes a number of different forms of marriage contracts. If I'm not mistaken, it's community of property, the accrual system, traditional marriages. Now there might be more than what our lay people can think of as common law marriage, and I mean, I'm sure you can search that on YouTube or speak to your attorney in that regard. The law also recognizes that the contribution to the union or partnership or marriage may be non-monetary. This is a very important one. It can involve labor input or even just the provision of friendship and comfort. This can complicate things when the joint owned assets need to be dissolved, because on the breakup of the alliance, the distribution of profit on the sale of the asset should also reflect, very importantly, the real value of the individual's input. And there will almost always be someone who will feel that they were shortchanged, that they were treated unfairly, or or dishonestly because they feel that they deserve more. But luckily the law is not based on our feelings. Just imagine if it was. So let's start with scenario 1. When the property is registered in both parties' names or only the husband's name, but in terms of the divorce order, the wife is entitled to the property or vice versa. Well, unless the divorce order provides otherwise, the correct sequence would be for the entire property or the husband's half share to be transferred to the wife. If the wife wants to sell the property without the property or the relevant half share first having been transferred into her name, the agreement of sale must be made subject to the transfer of the property or the half share to the wife. This is to protect the wife as the seller of the property, of course. This, however, does risk the agreement lapsing in the event that the transfer of the property from the husband cannot be done due to him frustrating the agreement, and therefore it is recommended to ensure that the husband or the wife, whichever the case may be, understands the obligations of the divorce order and will comply with the same before the agent accepts the mandate from the wife. If the husband refuses to cooperate, the wife would need to approach a court to compel him to adhere to the divorce order. Now, this is time consuming and almost always driven by emotions, which is not the ideal. So make sure that you select a real estate professional who is sensitive to the fact that you are splitting up. Often you'll find that one of the two parties would intentionally want to delay the process because, as I mentioned, it's quite an emotional process. The property is the last thing that binds them together, and understandably for some it's not easy to finally let go. What if, in terms of the divorce order, the property is to be sold and the parties will split the proceeds? Well, if the property is registered in both the names of the husband and wife, both the husband and wife will need to sign the mandate to sell, the agreement of sale or the offer to purchase, and the transfer documents. If one party refuses to sign the agreement or any of the other required documents, the other party would need to approach the court to compel the spouse to sign. The sale can't proceed without both parties' consent. If the property is registered in only one of the spouse's names, then the registered owner will need to sign the documents like the mandate to sell, the agreement of sale as I mentioned, and the transfer documents, unless of course the parties are or were married in community of property. But the divorce order is likely to prescribe the conditions of sale, including the payment of the proceeds. These conditions must be examined at the time of taking the mandate in order to ensure that the mandate terms and the subsequent offer to purchase the property will comply with the divorce order. In fact, I am dealing with a similar transaction at the moment, and it's not always that easy. It's very, like I say, it's an emotional roller coaster, and you just need to be patient and considerate. Thirdly, what if the divorce order is lost? Now, if a divorced party approaches an agent to sell their property but can't find a divorce order, a copy of the divorce order should be obtained from the court that granted it. If such party needs to list the property urgently, both parties' signature to the mandate should be obtained just to ensure that the agent has the necessary authority to proceed in the meantime. It's preferable for the agents to obtain this documentation before the property goes to market and before signing the mandate, of course, in order to ensure, and I know I'm hammering on this point, that they are mandated by the correct spouse or both spouses. Now, it's better to resolve such issues beforehand rather than waiting until after an offer to purchase has been signed and then only finding out that you require the consent of both spouses but only one signed, and this will surely complicate matters. I have experience of this, and may even compromise the sale and leads to claims by the purchaser. Now, in the fourth scenario, the parties were married out of community of property and the property was purchased by the spouse before or during the marriage. What happens then? Well, It's recommended that the real estate agent obtain once again a copy of the divorce order to ensure that no order was granted affording the other spouse any rights to the property. So what happens if spouses were married in community of property but have acquired property before the marriage? So whether it's husband or wife and the property is noted to only be registered in the name of the spouse who purchased it. So here is the dilemma, because now that spouse in whose name the property is solely registered in wants to sell the property. Remember, spouses were married in community of property. This is a real dilemma. This could have been prevented by an antenuptial agreement or a prenuptial agreement, whichever way you want to put it, which is an agreement made between parties before getting married, permitting them to individually retain certain assets during the marriage and during and after the marriage, if a divorce occurs. But in certain communities, this is considered to be almost like bad luck, because it's perceived as you are now anticipating a divorce, which is not true. This should actually be standard practice, everybody. It should not be offensive at all. And you should encourage your children to do so, even marrying out of community of property, especially if you plan to start a business. It just smooths things out, signing agreements. Even if one spouse gets a bad credit rating during the marriage, if you are married in community of property, both of you most likely won't be granted credit or that loan because one of you has a bad credit rating or a bad credit record if you are married in community of property, because you are seen as a unit to potential credit providers. You need to be aware that by virtue of marriage in community of property, the immovable property purchased before or during the marriage becomes the property of both parties, even if it's not noted in the deeds registry as such. Therefore, both spouses would be required to sign the mandate, the sale agreement, and the transfer documents. I hope that is clear. And lastly, let's say that the husband was married in community of property, but is subsequently divorced, and he remarried in community of property again. Now, I want you to listen carefully for this one. Now he is divorcing, and please bear with me, he is divorcing his second wife. So he was married in community of property, and married in community of property again, divorce, married in community of property again, and now she's divorcing the second wife. Twice divorce. The question is, how is this sale and the split dealt with? Well, as per the previous scenario that I've just covered, where spouses were married in community of property, I know it's complicated, but just bear with me. This is very similar. What you need to understand is the property becomes the joint estate of the parties of the first marriage. So let's put that one on the side so that you can understand. Now, if the property is not dealt with in the initial divorce, his first divorce, the parties of the first marriage will jointly own the property. They will jointly own 50-50. You understand that. So when the ex-spouse remarries, his half is then jointly owned by his new spouse. So the 50% stays with the previous wife. He only owns 50%. So in fact, she owns, that's his new wife, she owns 25% of the property that she contributed nothing to. And that is why there are so many infights and disagreements, and understandably so. But that's the law. Just imagine, she stole your husband. She made no financial contribution whatsoever to your house. You made the sacrifices. But by merely being married in community of property to your ex-husband, entitles her to 25% of your property, be it half of his 50%. That's the thing right there that irritates people. This means you would need all three parties to sign all the relevant documents, including her, like the mandate, the agreement of sale, etc. I've seen women getting livid which is somehow understandable, just to see the new wife's name and signature on that deed of sale or title deed, like the sales agreement. Just imagine. But that's the way the cookie crumble. And I hope that what I've shared with you in this video would be of value to you. And I would highly recommend that you encourage specifically young people, young couples, before they get married, to watch this episode, watch this video. They don't always understand the impact and effect of their actions and decisions. It's all good when things are all good. But what if life happens? If I should tell you, if I can tell you how many times people got offended when I speak to them about this, because in that moment, it's butterflies. They are in love. Nothing can go wrong. To them, the water is wet and the sky is blue, and nothing can go wrong. You need to remain sane when buying together. And wouldn't it be lovely if there was no such concept, no such thing as divorce, and people never got divorced? That divorce didn't exist. They stuck it out. Everything was perfect. But that is not the world that we live in. It's not. So make sure that you make informed decisions and share this video widely, so that we can equip our people with the tools necessary to make those calculated, informed decisions. And if you are going through a difficult time emotionally, talking about divorce and separation, and need some motivation and encouragement, please do check out my motivational channel called Life with Leonard. I will leave a link to my channel in the description below, or you can just click on the banner on top. It should take you to my channel, and I would advise that you scroll through videos there. There will be quite a lot of content over there that will inspire you and help you to deal with whatever you are going through. And just before I go, I don't know if you've noticed, but the jacket is green today. It's not really my jacket. Let me tell you what happened. My son, I had this on my mind. I came from a client earlier who was going through this, and I thought, let me just make a video about this. But all my suits went to the dry cleaners, so I don't have any jackets here. And I want to look nice for you all. I want to put on a jacket, etc. I didn't put on a tie today. But nevertheless, so I went to my son's cupboard, and he's a bit bigger than me, so this jacket is it's too small for him. So I thought, let me just hijack the jacket. I hope you liked it, and I hope it wasn't a distraction. But anyway, thank you so much for watching. Please don't forget to subscribe, like, and share this video as I ask you so nicely to do. And subscribing, it's two things. Firstly, it is absolutely free. It doesn't cost you a cent. And secondly, it is really easy, everybody. You can just click on that subscriber button in the bottom right hand corner of your screen. I always get confused because it's my left and your right, but bottom right hand corner of your screen. And please remember to hit the all notifications, and that way you would be notified and you won't miss out whenever I upload new videos. Thank you so much, everybody. I see you in the next episode. Stay blessed.